There are 10 things that I've come to think over the years are common avoidable causes of employers losing tribunal cases. And none of these are rocket science. Most of these are avoidable. They're in no particular order, so number 10 isn't less or more important than number 1. You've probably all looked ahead to see what number 1 is already, but I'm going to go through them. Number 10, employers who produce long, complicated procedures and then ignore them. Now, I'm going to insult all the HR people in the room. Is that all right? HR people love procedures and policies. Screw something up, let's make our policy a bit longer. Made a mistake, let's have a new policy to deal with. Problem is, the longer the policies get, the more policies you get in a handbook, the less likely it is that line managers will be familiar with those policies, know where to find them, or indeed read and follow them. And generally, as a rule of thumb, an employer who does something a bit silly might or might not get away with it in a tribunal. But they're less likely to get away with it if the HR department has previously written what to do down in a policy and they've breached that policy. I'm a big believer in keeping policies really, really short and only having 8 of them. The 8 on the slide. Disciplinary and grievance. A whistleblowing policy. Equality, maternity includes equal ops in there. Absence management. Bribery, because that's a legal requirement for big companies. Internet and social media. An expense policy. And again, because it's a legal requirement to health and safety. Does anyone think I've missed any that are necessary and that benefit employers? Was there one there? Someone's got to have the courage to say one. Debt collection. Sorry? Data protection, what was your one? I'm not even sure I know what that means. Data protection. Data protection I'm terribly unconvinced about, because data protection, first of all, nobody ever reads or understands a data protection policy, but leaving that aside, all the data protection policy will say is don't tell everyone else's personal stuff. But that can go quite adequately into a disciplinary grievance policy in one bullet point. I don't think it adds anything to have 50... Yeah, go on.
Performance management.
Performance management. You're absolutely... There are 9 policies that everybody should have. Performance management. That definitely deserves an Amazon voucher. Catch, where are you? Right, I'm warning you now, you guys here, when I flick these, they go in any direction. Watch your eyes, okay? Here we go. No, I'm not taking any more. I'm not going to look even more stupid. Number 9. Not allowing recording. Anyone mind if I take... What do I care? Refusing to allow recordings of meetings. Lots of HR people will go into a disciplinary or a grievance hearing, and the employer will whip out their iPhone and say, can I record this meeting? And the stock response of most HR people, not all, most, is to say no. Who would say yes? Of course you can allow the meeting. I would guess about, you put your hand up and change your mind, 12 people maybe. Who would say no as a matter of course? Similar number. Well, since we know half the room's HR, 80% of you aren't actually voting. Most HR people, and certainly this is my experience, will routinely say no to... Who said no? Just put your hand up again. Higher? Higher? OK, can we get a couple of mics down here? Lady in the blue cardigan. Why wouldn't you allow recording of a meeting?
Because you don't want it used against you.
Right. Do you know what? That is...
I just wanted to say something which is quite amusing. We had a very, very detailed disciplinary hearing, and the chap that we had involved in the hearing was incredibly difficult. So we recorded professionally the whole session, which went on for some hours, and he complained about the content of the recording, so you can't win either way.
Well, let me come back to that point. Your point, deniability. You don't want it to be used against you. That's the truth. We all know it. When you cross-examine HR people, which I do quite often on this exact point, that's the first time I've ever heard anyone give the truthful answer. You've completely taken the wind out my sails. You'll get all sorts of crap. You'll get people saying data protection. We can't record it because of data protection. You'll get people saying, well, we're taking a note, so there's no need to have two versions of the record, which is, why would you prefer an inaccurate version over an accurate version? But it does come down. It's exactly the same. Why do you think judges don't allow you to tape tribunal proceedings? It's deniability. But the thing is, judges know that. They know that some HR people want to have the opportunity to ensure the record reflects that which they would like it to reflect, to finesse, to take out anything that's stupid, to put in anything that's not. I was telling you before I stopped telling you, but I'll tell you now about this case I did involving the high street chain where a couple of employees were sacked for theft. And they said in their ET1 this very gregarious owner of the business had come in to the disciplinary meeting. During the disciplinary meeting, he had no right being there, head of HR was there, started banging his fist on the table and saying, you tell me where the stock is, or I'm going to get you all sacked and I'm going to make sure your family are deported. And it went on in that vein. And he was using some fairly colourful language. Anyway, we in the ET3 denied that the owner had ever walked in the building, in the room. The witness statements, I wasn't involved with the ET3, but I drafted the witness statements. I was assured by the head of HR and the in-house lawyer who was in the room the owner had never walked in the room, so we had statements from head of HR, in-house lawyer, the owner. They said that in their evidence in chief. Then I got to cross-examine the two employees, the manager and the assistant manager, and I said, I put it to you that you're lying about the owner coming in the room. And the first person I asked this to, the manager, he said, well, do you want to hear our recording? Being Litz in person, they hadn't known about disclosure. And of course, if you don't let somebody openly record a meeting, they might covertly record the meeting, which is the big problem. Because then if you produce a transcript which doesn't quite match what's on the recording, you're sunk. I don't suggest that employers actively go and record proceedings. A couple of exceptions, public authority, it's often done. But generally, tribunals are still a little bit stuck in the 1970s and think if an employer says, I'm recording the meetings, it's a bit weird. But if the employee says, I'd like to record the meeting, I'd always say yes. If nothing else, it avoids the hassle of sending the employee your notes of the meeting and then having weeks and weeks of argument which is never resolved about whether the notes are accurate or not. But with one caveat, it is worth asking the employee to either assign copyright to you or to at minimum undertake that they will not post it on YouTube, Facebook, whatever it might be, because you don't want those recordings in the public domain. And although in practice you probably wouldn't enforce it, you would want to have an enforceable document allowing you to force them to take it down. Number 8, create a culture where appeals are never successful. There are two things that lose cases most frequently in my experience. Number 1 is the employer not giving all the relevant documents to the employee in time. Number 2 is an insufficiently rigorous appeal process, because it's usually screamingly obvious when the appeal manager has done nothing more than rubber stamp. Appeal managers used to be line managers. Line managers hate appeals being allowed against them. They regard it as a black mark. And the appeal managers think there but for the grace of God go I. They think, I didn't want this done against me when I was a line manager. I won't do it to my subordinate. But it's so easy for a good cross-examiner to make it very obvious that an appeal process lacks scrutiny, lacks rigour, and has just been a rubber stamping exercise. Any appeal process that can't demonstrate an appropriate level of vigour is a hostage to fortune. So you need to train managers that having an appeal allowed isn't a black mark. Think about this. Psychologically, this is something quite useful to tell managers and appeal officers. Psychologically, an employee who's dismissed and then reinstated on appeal is going to be the best behaved employee you ever have. And if they're not, they're the easiest employee to sack all over again, because any tribunal is going to say any small episode of further misconduct is enough to tip the range of reasonable responses over the edge. Any questions on that? Number 7. Allowing office... This is about the statutory defence. Let me tell you, does anyone not know what the statutory defence is? I'm very happy to run through it really quickly. Okay, In Equality Act claims, in harassment claims, normally an employer, the company, will always be liable for any discrimination or any harassment by one member of staff on another. It's just automatic. There's some room to dance around the edges, for example, at the staff Christmas party that's at a restaurant 2 miles away. But generally, leaving aside those edges, the employer is always responsible for any harassment or discrimination by an employee unless the employer can prove something called the statutory defence, which is in the Equality Act. And that says that if the employer has taken all reasonable steps to prevent the harassment, to prevent the discrimination, then they won't be liable. Now, lots of employers have lots and lots of policies to cover this sort of thing. I've never won a statutory defence argument. Has anyone won a statutory defence argument? No? Statistically, I would have thought there's got to be a couple of people in the room, but no. And there's a reason. Almost all companies get 90% of the way towards establishing the statutory defence, but don't go the last 10%. 90% involves, certainly for bigger companies, because small companies can never do this, they don't have the procedures in place, it involves induction for new employees that includes an element of training on equal opportunities and harassment and discrimination. I'm not talking about teaching them what the Equality Act says in detail, it's just the headline points. It includes having a clear policy that's distributed to employees, prohibiting discrimination, prohibiting harassment, and making sure it's regularly reviewed and updated. And it's about having an effective, robust grievance procedure. So if someone complains of harassment, it's taken seriously by the company and not swept under the carpet. That gets most companies, because most big companies do all those three things, it gets them 90% of the way there. There is 10% missing. And if companies bring in this 10%, they'll establish the statutory defence and will get out of liability for discrimination cases. And that extra 10% is simple. It's having regular updates for the staff on equal opportunities. By which I don't mean having everyone into a room like this once a month. I mean sending out an email once every 6 months, or a sheet of A4 once every 6 months, possibly once every 12 months. 6 months is safer. Just with half of it can be key reminders on a different aspect of discrimination. So, for example, just talking about what sexual orientation harassment is, or just reminding people what indirect discrimination is. So a headline point, and half of it just with a couple of updates of recent developments in equality law. And as long as that's done regularly by companies, they'll get the statutory defence there. It's such an easy extra thing to do. There are companies that do this. Byrne-Dean, does anyone use Byrne-Dean? B-Y-R-N-E-D-N? Yeah, are they good? Do you like them? They do exactly this sort of training for equality. Matt Dean, used to be a solicitor for many, many years, a partner, I think it was Clifford Chance, certainly one of the, Simmons and Simmons. Was it Simmons? Yeah, Simmons and Simmons. He really knows what he's doing. He's not a mate of mine. Great. Just said to 200 people he's not a mate of mine. He is a very nice guy, but I don't know him very well. I used to be on a committee with him years and years and years ago, but he is the market leader in this sort of thing. Number 6. This is what I was talking about first thing this morning. This is the situation where an employee gets a letter saying, we're having you up on a disciplinary. And they do one of two things. They either go off sick with stress, or they put in a grievance. Either way, trying to derail the disciplinary process. Now, there are 2 ways of dealing with this. There's the way I'm about to tell you, or if you're in a local authority, they're sitting around for 3 years and doing absolutely nothing. To be fair, that used to be the case. Local public bodies are now better at it. It's rarely more than a year. Here's what to do. I'll deal first with the person who goes off sick with stress, then I'll deal with the grievance, the person who puts in a grievance. Any doctor will tell you, any tribunal judge will agree, that the best way to remove symptoms of stress is to remove the cause of stress. And whilst the disciplinary is hanging over the employee's head, it is an ongoing cause of stress. Therefore, get on with the disciplinary and remove the cause of stress. Now, the employee will have turned up with their fit note from their GP saying this person is not fit to work. Fine. You're not asking them to work. What you're asking them to do is attend a 1-hour meeting and respond to allegations. What you need to do as the employer is get the employee off to your occupational health department and ask them, or your outsourced occupational health, and ask them, is this person fit to attend a 1-hour meeting to respond to allegations of misconduct? And any occupational health worth their salt will answer that yes. And if they don't answer it yes, sack them and find a new health provider. I say that slightly flippantly. There will always be cases where someone is genuinely unwell, and in that situation you have to treat it much like any other sickness absence situation. But, can we get a mic just here? Sorry. But in 95% of cases, and judges know this because judges used to be practitioners and judges have heard it 1,000 times. Two seconds, Neil. Judges have heard it 1,000 times. The judge will start from the assumption that if someone goes off sick straight after getting a disciplinary letter, it's because they're trying to avoid the disciplinary. Neil Russell.
Daniel, just a short question. It's not just attending the disciplinary hearing, which might last an hour and a half, 2, whatever.
Yeah.
It's also the preparation. And therefore, perhaps it's good to check whether or not the employee is capable of preparing properly for it as well.
Yep, that's a fair point. Personally, I wouldn't, because if you say that, it makes the occupational health person slightly less likely to say, yes, they're able to attend. Let the employee take the point if the employee wants to take it, but bear in mind also that what the employee will tend to do is come with evidence from their GP, and Occ Health trumps GPs. If they come back with evidence from a consultant psychiatrist, that will trump the occupational health report, and you'll have to put things on hold. But that's relatively rare. Does that answer the question? You look up.
Ordinarily, the occupational health may not necessarily consider the preparation required for the disciplinary hearing. And then you have that difficulty when they say, well, we're not really ready yet, because we haven't been able to prepare.
But if they say they haven't been able to prepare and it's credible, if they've had a week and they haven't got medical evidence to combat occupational health saying it's okay to have a meeting, if they've had a week, it's generally, a tribunal would generally say it's reasonable to proceed anyway, because they've had a week to prepare and not provided medical evidence to say that they're not able to prepare. I think they would need the medical evidence to support that sort of thing, and they should get it, not the employer. Just 2 seconds. Yep.
It's not a question, it was just, I've had that situation, and what we did, it wasn't a unionised place, but we offered them another employee to help them prepare, give another employee time off to help them if they wanted it.
Yeah, good practical point. Thank you. So what you've got is let's assume you've got an occupational health report and they've said fit to attend a meeting. You then send it to the employee and you say, come along for the meeting. Come along next Tuesday, we'll see you then. Offer the neutral venue, offer doing it by telephone, offer written responses, do all the normal things, but say the meeting is taking place on Tuesday. And if they don't turn up, fine, write to them again. Remember, you've still got the dominant medical evidence at this point, unless they've produced something that trumps your Occ Health report. Write to them again and say, we're sorry you didn't turn up, we're going to reschedule for next week. Come along, but if you don't turn up next week, given that Occ Health has said you are fit to attend, we're making a decision in your absence. And no tribunal will say that that is unreasonable. Because again, tribunals are coming from the starting point that they've seen this a million times, both in practice and as judges, and they kind of assume that somebody who has gone off sick straight after a disciplinary letter is given to them is trying to avoid the disciplinary. So we've had 2 people who are saying they're judges. Do you agree with that? Oh, we've all gone quiet. There's a judge over there? Not want to comment? No, okay. So that's the basic disciplinary going off sick position. The other position is if the employee puts in a grievance. And there are 3 types of grievance that can be put in here. Number 1 is a grievance attacking the process. Number 2 is a grievance attacking the decision maker. I don't want Fred Bloggs to hear my disciplinary because I slept with his wife and he's biased, that sort of thing. Number 3 is a grievance that relates to the underlying allegations. Let's deal, and I'll explain what I mean by that in a sec. Let's deal with them in turn. So number one, Christ, what was number one? Process. Number one, a grievance that deals, that attacks the process. These are great. Because if the employee writes a grievance letter and says, I think the process is unfair because you've not given me a key document, you give them the document, and you've completely closed down that line of attack on an unfair dismissal application. If it's a silly point, and it's often, and by the way, the ACAS Code of Conduct says that if an employee raises a grievance during a disciplinary, there's no obligation to adjourn the disciplinary. It's completely the employer's decision whether to deal with them concurrently or put one on hold. And you'd nearly always want to deal with them concurrently. If the grievance is something like, if it's something stupid like, your grievance procedure says that I can be accompanied by a trade union rep or a workplace colleague, but your letter to me says you can be accompanied by a trade union colleague or a workplace rep, therefore you haven't followed your procedure exactly, therefore please drop the entire disciplinary because it's unfair. If it's something stupid like that, you just write back and you say, thanks, that's a really interesting point. I tell you what we'll do, we'll discuss it on Tuesday at the meeting. And you just deal with it at the disciplinary meeting the following week. Second type of grievance, which is attacking the decision maker. Could be something along the exaggerated lines, slept with my wife, could be just something like, they don't like me. The response to that, two possible responses. Number one, you can get in a terrible fluster and launch an investigation into bias on the part of the chair. Or you can just say, whatever, and write back and say, that's a really interesting point, tell you what, someone else will share it. And just get on with it. We'll see you next week. And if they object to that somebody else as well, you offer them two more names and say, pick one. And if they object to those other two, no tribunal in the world will criticise an employer that nominates one of four offered people after all four have been rejected by the employee. So the answer is consistently, we're getting on, we're pressing on. We're running this disciplinary process, not you. It's happening next week. Now, grievance number three is something much more fundamental. So, for example, let's imagine it's a conduct, theft from a shop, dismissal situation. And the grievance is the investigating officer planted all this on me. Or the investigating officer has a grudge against me because I blew the whistle against him a year ago. Now, when it directly impacts on the integrity and the reliability of the investigation, you can roll it all up again. You don't need to adjourn the disciplinary. That's a really interesting point. Tell you what, we'll put things back for 2 weeks, give us more information, we'll ask the investigating officer about it all, and we'll deal with it as part of the disciplinary. And that's all that needs to be done. It doesn't need to derail the process. The one possible exception to that is if the employee raises something to do with, for example, ongoing workplace harassment or discrimination, where some employers will want to be seen to be taking that very seriously and will say, let's put the disciplinary on hold. But again, it's not necessary, because what can equally be done is the employer can say, well, this is really serious, we need to investigate it, but we're going to park it until after the disciplinary. If you're still on the payroll, we'll deal with it. If you're not, you can decide whether you want to continue with the grievance or not. 50% of the time they'll drop it. And if they want to continue with it after the disciplinary process has been finished, and we're assuming that they were dismissed as a result. Does that kind of make sense, all of that? Yeah. All right, any questions on that? Yeah, can we get a mic there? Any other questions? Just getting the mics to the right place. No? Lady right at the end, second from the end.
With the disciplinary
or stress followed by disciplinary followed by sick leave. Do you think there are any parallels in dealing with it the same way, where you instigate performance management proceedings and someone says, oh, you expect too much now, you've really stressed me out, now I'm off sick, and they go and get signed off sick? Because you might be able to get the first meeting dealt with if they refuse to come and say they won't attend, but then without coming back into the workplace and actually trying to improve and work with them, it doesn't seem that you can get much further, but they just don't want to engage in that sort of process.
Yeah, so do you treat it as a absence issue rather than a refusing to cooperate with the disciplinary issue? Is that what you're saying?
Refusing to cooperate with the performance management.
I'm slightly confused, I'm sorry. If it's originally disciplinary, they go off sick, say stress...
No, so it's not a disciplinary. So you start performance management, you say, right, there's a real issue here with performance.
Yeah.
They say, now you've stressed me out, go off sick. Do you think you can say, along the same lines, well, if you sort of don't come to a meeting to discuss your performance, then we may have to sort of look at your performance and sort of take a first step in your absence?
I don't think you can, because normally performance issues aren't things that would result in dismissal. Management without them coming and contributing, you'd then be in the position where you might have given them a warning and some targets for performance management, but they're still off sick. And then it has to convert into an absence management anyway. So knowing it's going to convert into absence management at some point, it's probably prudent just to treat it as absence management from day one in that situation. Right, any other questions? Yeah. You're going to get an extra T-shirt for the most questions.
Can I get a copy of your book instead?
By all means.
I think just from an in-house perspective, in my experience, the key challenge here is that everyone just gets bogged down during this process. And however agile you try and be, and however much kind of agile advice you try to provide as an in-house lawyer, you just can't avoid getting bogged down. So have you got any hot tips to help us?
There's one thing you've got to remember when it comes to disciplinaries and the process. Yeah, the disciplinary process is next Tuesday. We are focusing on that and nothing else. It's just what you've got to keep remembering and pressing on with. And I know it gets tied down in I went through this. I know it gets tied down in internal politics, but it's just a question of overcoming the internal politics. From a legal perspective, you just press ahead. Can you pass that back? Thanks. What have we got? Tone matters. That's really boring. I'm not going to do that. Dealing with performance issues. Do you remember I said, be nice until it's time to stop being nice? This is what I mean. We all get phone calls, whether we're HR or lawyers, from line managers who say, I want to get rid of Fred because they're crap at their job. And you say, can you email me over the most recent 2 annual appraisals? And they send it over. And of course, that line manager has given the employee 5 out of 5 on every possible key performance indicator, sprinkled rainbow fairy dust all over the appraisals, and put SWALK at the bottom under the signature. Performance appraisals are when it's time to stop being nice. Because if you think about it, there are several reasons why companies do performance appraisals. It is to identify and reward good performance. It is to identify and monitor poor performance. And it is to set training needs and career aspirations. A cynic would say that if there was also an idea in the employer's mind that this employee is going to go on to performance management at some point, the 4th motive is to start laying the paper trail. But whether it's 3 or 4 motives behind annual appraisals, none of them are served by being unfairly nice to employees in their annual appraisals. And the key rule, I think, here, this isn't from any case law, it's just my own phrase, in annual appraisals, firm but fair. Firm but fair. That's what's got to be driven home to managers. Managers who are too nice, it bites them down the line when they try to do a performance dismissal later. And some big companies do something incredibly successfully. Won't really work in small ones, but big companies, they have key performance indicators at the annual appraisals for the managers themselves, and one of those KPIs is how well they do annual appraisals for their subordinates. So there's a statistical analysis, and if a manager has given everyone 5 stars and a smiley tick, then they'll get marked very low on their own KPIs, which they don't want. So it's an encouragement for line managers to do these things properly. Hope grievances will go away. Grievance is a warning you've got a problem. Might be a small problem, but if it's ignored, a small problem turns into a big problem turns into a massive problem. There is case law on how quickly employers should deal with grievances. And it's amazing that it's a case that I would have thought would be at the forefront of everyone's mind, and relatively few people in my experience seem to know it. I won't ask anyone for the name, but does anyone know there is a case that says if you don't deal with a grievance as an employer, if you don't deal with a grievance within a certain period, then unless you have a good reason for it, it's going to be a constructive dismissal. Does anyone know what that period is? 3 months. Yes, very good. Did anyone else know that and was just staying quiet? One other person. Do you know the name of the case for a bonus? There's Gould and McConnell, G-O-O-L-D, against McConnell. T-shirt, here you come. You've got a T-shirt. Amazon voucher? Excellent, can you pass that back? Thanks. Just shove your hand up so they can see who it is. These are only 20 quid Amazon vouchers being thrown out at the moment, by the way. The big 50 quid one is for whoever gets my steps right, or at least closest. So, unless you deal with the grievance within 3 months, says the case law, Gould and McConnell, then it is a presumptive constructive dismissal. When I used to act for employees, I used to have such fun cross-examining HR people when they dealt with grievances, because it was just so easy to take pot shots at people for not going down every single possible investigative route. And you could just attack someone so easily for not looking into that, not looking into that. About 2 years ago, I did 2 grievances myself as the investigator. One was an internal chambers grievance where we had 2 members of staff with a grievance, and I investigated it. The other was a professional thing where I was instructed on behalf of a charity that you all would have heard of, where the marketing director put a grievance in against the CEO. And so I did the investigation, but I came to realise quite how difficult it is to do a grievance really, really well. Because every time I asked a question, I got 7 forests worth of information back in reply, opening all sorts of other avenues. It takes forever to do it's not going to stop me from taking cheap pot shots at HR people in cross-examination, but I actually came to realise it's really difficult to do a really good job on a grievance investigation. But tribunals don't expect you to do a really good job. They expect you to do a reasonable job. That's the magic word. As long as the main issues have been canvassed, investigated, examined, and decisions made, which are based on the evidence, then it's going to be okay. Deal with grievances within 3 months. Here is a direct quote from every single person in this room, every single person's handbook, employment handbook. You have the right to be accompanied by a trade union representative or a workplace colleague. Because everyone has the same phrase. It's lifted straight out of the Employment Relations Act. And as a result, some companies take the view that they should add the words in there, in their own heads, not in the policy, in their own heads, and no one else. But that, of course, isn't what the Employment Relations Act says. What it says is this is the minimum right to be accompanied by a workplace colleague. I'm parking here, by the way. I'm parking the issue of reasonable adjustments of letting people into a company disabled employees. Just dealing with the average employee who's not disabled. Under Section 98(4), the fairness of a dismissal, a tribunal expects an employer to act reasonably. That might sometimes entail allowing someone else into the room who's not strictly a workplace colleague or trade union rep. Anyone here ever... now, which union is it that did it? I think it was Unite, but I'm not 100%. Could have been the ATL. We've got people here from the ATL, haven't we? I think we have. I think we've got 3 people from the ATL. 1, 2, I'm sure there are 3. Tell me if this was you. There was one union that a few years ago had this brilliant wheeze of certifying random people to accompany employees into disciplinaries. So, because you don't have to be an actual trade union official to have the statutory right, you need to be certified by the union as entitled to accompany people. That's just signing your name on a bit of paper. And one, was it the ATL? No, it must have been Unite then. I think it was Unite, had this brilliant wheeze of basically certifying whoever their member wanted to go in. So if their member wanted a lawyer in there, they'd certify a lawyer, who'd then have a statutory right to go in. If they wanted their mum in there, you get the point. Anyway, leaving that aside, it can be quite helpful to let the employee have whoever they want in there. Because the person the employee wants, let's say it's a 16-year-old employee who wants his mum in the meeting. The person that they want will generally be the employee's most trusted advisor, the person whose opinion they trust and canvass the most. And if you imagine the situation, let's say 16-year-old boy hauled up charges of gross misconduct. He goes home and he says to his mum, you won't believe what they've done. They're threatening to sack me because I used a postage stamp for a personal letter. And the mum says, I'll come into the meeting and tell them what for. And so he asks if the mum can go in. Company says no, they sack him, and the mum says, right, this is outrageous, I will fund you going to an employment tribunal. I'll pay the £250 issue fee, let's take this to court. If the employer had allowed the mum to go in, she might have seen the evidence, which isn't that the boy was sacked for using a personal postage stamp. He was sacked for, when being told off for using a personal postage stamp, he pulled out a Colt 45 revolver and shot the managing director point blank in the face. Rose-tinted glasses are a wonderful thing, and employees give false impressions to their loved ones. If those loved ones are in the room, they will see the weight of the evidence and might not encourage tribunal litigation. The one person you should never let in a room, by the way, is a lawyer. There is an exception to that. If it's a career-ending allegation, for example, in the financial services sector, there's case law that says lawyers are allowed in. But generally don't allow lawyers in because their only purpose in being in a disciplinary or a grievance is to make life difficult for you if you're the employer. I did this once. I once represented she was a partner in a small firm of solicitors where she had been caught with her hand in the till. She was a probate lawyer stealing from dead people. And she asked me to represent her through a firm of solicitors, asked me to represent her at the disciplinary. My brief was basically to just get a mutual termination because she didn't want to be dismissed for gross misconduct. You know, she wanted to go and steal from dead people from another firm. I'm being slightly unfair. And so my brief was to be as difficult as possible. We went into the disciplinary. This was years ago. It was before the days of iPhones. I slapped down a dictaphone on the table and said, I'm recording this. Yeah, not can I. I was just trying to be confrontational and wind up the senior partner who was in there. Anyway, senior partner started reading from a sheet he had. We're here today to discuss, at which point I interrupted and said, can I have that? And he was obviously taken aback. Why? Because I want it. No. Why not? Because it's my notes. Well, they're going to be disclosable when we sue you, aren't they? I suppose so. Are you planning to change them between now and then? No, of course not. Then why won't you give them... Anyway, it went on in that vein. She still got sacked for gross misconduct. But don't let lawyers into meetings because the brief is just to screw things up for people. Number one, panic when a female employee gets pregnant. 2 secs. If you know the name of this firm, don't say it aloud.
This isn't a pregnancy question, it's okay. In terms of being consistent, which I think is important, and you put it in your top 3, how do we do that when it comes to not allowing certain people into the room?
Sorry, not allowing?
Certain people into the room. So I mean, the reason that we stick to the words workplace colleague, trained union rep, is so that we don't inadvertently let a lawyer into the room and have our line managers blindsided by someone like you, no disrespect intended. I can see how that would absolutely terrify them. And quite honestly, from an HR perspective, it would terrify me to have you across the table. So we stick to the words and we hold to them.
Yep.
What would you have me say in the policy instead of those words?
No, the policy should say exactly that.
So
no
then
need to change the policy. But if they say, can my mum come in, I would normally just say, OK, fine. Remember, consistency doesn't mean only allowing a trade union rep or workplace colleague in. Consistency means just that. So as long as you have a policy, even if it's not in the written policy, and this is why I hate policies, but even if it's not in the written down document, as long as your practice is to depart from the written policy to allow mums, dads, spouses, but not lawyers in, and as long as you're consistent in the way you depart from the written policy, I
can see that. Test. And a lot of the husbands, spouses, partners where I am may very well be employment lawyers, which was why, hence the question,
yeah,
how do I get around that one and be consistent and fair?
That's a quandary. I would always take the view that the lawyer trumps the spouse. So if they're a lawyer and a spouse, don't go near them. Don't let them in.
So you ask the question directly, or no, is the person you're bringing an employment lawyer?
I wouldn't ask the question, but on the other hand, if they misbehave in the meeting, that would be a reason to adjourn the meeting for half an hour and say, calm down. And if they carry on misbehaving, then you say, right, we're dealing with this now tomorrow, and you're not welcome back. Because when you're outside the strict statutory entitlement, workplace colleague or trade union rep, you can do exactly that.
Thank you, that's helpful.
Yeah, good. Sorry, question there somewhere?
Right. I don't know if this is useful, but we work in the public sector and there is a decrease in trade union representation, and I have worked in organisations that have trained people to support members of staff in disciplinary and grievances to deal with the issues we were talking about earlier around the lack of power, and if they haven't got a trade union rep and the emphasis is not to allow mothers and spouses, then we feel it's only fair to have somebody there. So I hope that's useful for some HR people that might consider that as an option.
Yeah, thank you. All right, panic whenever anyone gets pregnant. I'm running dreadfully behind, by the way. I'll still finish at 4:30, but I'll just have to talk even faster. Right, pregnant women, I'm using a wrap-up phrase to cover pregnant women, women on maternity leave, women returning from maternity leave, all those things. It's just too much of a mouthful to say that every time, so I'm just saying pregnant women to cover all three of those. Now, pregnant women have 5 rights in the workplace. They have the right not to be discriminated against. They have the right to return to work. They have the most ignored right in the history of the world, which is the right to have a risk assessment carried out. They have the right to reasonable time off for antenatal care. Anyone know the 5th? They have the right to trump other candidates for redundancy if there's a redundancy situation and they are suitable for the role. Very good. So those are the 5 rights that pregnant women have. Here are some rights that pregnant women do not have. Pregnant women do not have the right to immunity from redundancy if their roles are redundant. Lots of employers panic in that situation. Eversheds panic. Does everyone know the Eversheds case? Some people, Eversheds. They made some people redundant probably about 10 years ago now, 5 years ago? A good few years ago. And they did a selection, it was some lawyers, it was a matrix selection process. There was a woman on maternity leave. They scored her 6 out of 6 for billing, even though she'd been off, because they didn't want to score her 0 out of 6 because they thought she'd sue them if they scored her 0 out of 6. So they scored her 6 out of 6. She just pipped a man at the post because she'd got 6 and he got 4. And as a result, the man got made redundant. His name was Mr. DeBellin, and he brought a claim for sex discrimination against Eversheds, saying, you've treated me less favourably by not bumping me up to 6 out of 6 because I'm a man, not a pregnant woman, and he won. and he got compensation for being made redundant. And it kind of suggests if Eversheds can't get it right, who can? But it's a constant problem for a lot of organisations, how to deal with redundancy when you have women who are away from the workplace because of maternity leave. The key point is women who are pregnant or on maternity leave are not immune from redundancy. You've got to be careful when scoring them. And of course, in the Eversheds case, although the Employment Appeal Tribunal said the employer shouldn't have done that, unhelpfully they didn't go on and say how the employer should have dealt with it. But the general rule of thumb is you do the best you can to recreate what would have happened if the person on maternity leave was at work. Often best done by looking at their 6 months billings from before they went off on maternity. So pregnant women don't have immunity from being made redundant. Pregnant women don't have immunity from being dismissed for performance or conduct-related reasons, even though the employer might be terrified of starting those proceedings. I did a case with Neil Russell just down here from BD Laddie 3 months ago. We had we acted for a small wine company. It was you, wasn't it? Yeah. We acted for a small wine company where the owner of the wine company had a marketing manager who he didn't particularly like. He wanted to dismiss her, started to talk her, she'd worked for less than 2 years, started to talk to her on a Thursday afternoon about your performance isn't up to scratch, we've got to do something about this. Got cold feet, went home on the Thursday, but she'd got the direction of the meeting, so over the weekend she emailed him and said, guess what, I'm pregnant. He then sacked her on the Monday, and although ultimately he won the claim, because the tribunal believed he was going to dismiss her anyway, it cost, well, Neil's very reassuringly expensive as a lawyer, it cost him a huge amount of money in avoidable legal fees because he'd just not grappled with things. If somebody is pregnant, be cautious by all means if you're an employer thinking of dismissing them, because it's often about perception. But there is no rule of law that says a pregnant woman, as I said, has immunity from performance, capability, conduct dismissals, or things of that nature.